First of all, the court started the case with, if you look at the docket, it says divorce. This is not a divorce case. The divorce case is fraudulent, and I filed twice to dismiss it, and twice the court did not rule. The first time, Judge Grump denied my motion as a matter of law, stating in her order, if Your Honor would have a look at it or want me to show it on the screen, she stated literally that because I cited the wrong law, simply, where I didn't. And she named it. She named Rule 91 or Federal Rule 20 or 21, I'm not quite sure. But bottom line, the first time, the judge did not rule on that. Bless you.
Thank you.
The second time, Your Honor, Judge Meacham heard the case. First of all, Judge De La Yata, out of his own choice, it wasn't, I did not request anything to do with the divorce case. My motion was simply to order Miss Longwitz, admonish her from using the divorce caption in the marriage of, which she was wrongfully using. She changed the caption of the case from a SAPSER caption, Marius versus Dima in the interest of the child, into in the marriage of. She started that way early when she filed her motion for continuance, and that's where I'm saying she misled the court. In her proposed, Judge De La Yata has no clue about divorce or what have you.
Wow. Now see, here's again, Mr. Lemnisa, stop. Okay. When you start, we have officers of the court, we have judges and attorneys. When you start throwing out words like that, like Judge De La Yata has no idea about divorce,
I apologize. Can I rephrase, please?
No, you need to back off on that type of thing. It's like saying Ms. Longwitz is a liar. Like, that is not helping you at all. It would be a little like me going over and criticizing, I don't know, a NASA rocket or something. You need to keep in mind that folks here do have a reputation. And Judge De La Yata, to say he doesn't know anything about divorce, you don't know what you're talking about.
That's not what I meant, Your Honor.
Yeah, you need to back off on that. And you need to wrap it up.
Can I explain, Your Honor?
No.
Can I rephrase?
No, don't explain why you just cast aspersions at Judge De La Yata. You just sit with that.
I did not. What I meant, I misspoke, Your Honor.
Move on.
I didn't say it would be easy, Neo.
Good morning, everyone. This proceeding is being live streamed on YouTube consistent with the open court's provision of the Texas Constitution. If any of the parties have an objection to the live stream, kindly bring up your objection to Judge Angelo when she calls your case. With that being said, the 455th District Court is now in session. The Honorable Judge Angelo presiding.
All right. Good morning, everyone. It's Judge Angelo here. We're here on a case Lamnisos versus Zanen. Again, Ms. Guardiola, for some reason I lost my message here where you had put that docket number. I'm looking for it. If you could re-message it, I would appreciate it. There it is. We're here on D-1-FM-23-002729. May I please have announcements first by the petitioner and then by the respondent?
Mario Slamnisos, petitioner, Your Honor, representing myself.
All right. And who's here on behalf of respondent?
Julia Boyce and Gina Longwitz for respondent.
All right, very good morning, Ms. Boyce, Ms. Longvitz. Okay, very good. So we're here, if I am understanding, I'm going to turn the volume up a little bit. Who's brought this motion? Mr. Lamisos, did you bring this motion?
Yes, Your Honor, I brought all three of them.
All right, so tell us what you're here on then, sir.
I have a small request at the beginning before we start, if you would, Your Honor. Because of my situation, I didn't get the chance. I just learned that your court will be hearing, was assigned this case is like half an hour ago or a couple of hours at best ago. My request is we just go in order, if that's agreeable to the court and to the council. In other words, in the past, my experience was having several motion heard at the same time where I get lost. I have a problem with focusing and attention. So if at all that's possible, I would appreciate it.
I will, that's an accommodation request. I will grant the accommodation request. So please tell me just right now in one sentence, what are the three motions you want to consider, and then we will consider the first of those three. Okay?
Okay. The first motion, Your Honor, is the motion to approve the indigenous statement and to waive the transcript fee, or in the alternative, tax that as a court cost.
Okay.
And
What's the second one?
The second one is motion to set aside the default judgment.
Okay. And what's the third one?
Is motion for new trial, Your Honor.
All right. All right, very good. Let's start first with the motion to approve, I guess it's a waiver of the transcript fee.
Yes, Your Honor.
All right, Ms. Longvitz, how do you respond to that?
I also need to note, I'm a state
Ms.
bar.
Boyce, I'm sorry.
No, I apologize. I have to note for the record, I'm a state bar qualified law student working under the supervision of supervising attorney Gina Longwitz. I forgot to note that. We have no position regarding Mr. Lamnisos's motion to approve statement of inability to pay cost and request for transcript fee waiver.
Okay. Mr. Lamnisos, the court was going to need to review your statement. I can't grant it without spending some time on it, and we have not had that opportunity yet. So at this point, I can't guarantee you that we're going to grant it or deny it. I just need to look at it. So we're going to take that under advisement. Mr. Agidi, please make a note of that. That is an issue we're taking under advisement.
If I may, Your Honor, it's just that in the motion, the statement is included both as an exhibit to the motion, and also it is already been on the file, the case file, twice. Once the first time, and then an updated one. And the last thing I would like the Honorable Judge to consider is that it was implicitly accepted. The only reason I'm asking for an official approval of the court is so I don't have a problem obtaining the transcript without the fee, since I can't afford that.
I will say this, that I understand what you're saying, you can't afford the transcript, and
Yes,
that may very well be the case. There are, as you can imagine, pretty strict rules here at Travis County about these,
Yes,
and you may have met those. I don't know. I just can't grant it without looking at it, because the problem is that there's a limited bucket of money to pay for these things. And if I grant yours in error, because I haven't had time to look at it, then that could be a problem for another party down the road. So I need to make it really sure that it's clear. And this goes to my court reporter too, because if you need a copy of the transcript, then she has to make sure she can get paid from that bucket of money. If she can't, she won't get paid for the transcript. So I have to review it very carefully. It's not something that people just automatically get because I asked for it. So I'll look at what you've got, and I'll get back with you later, okay?
I understand, Your Honor, especially that it's more than one transcript. I need like several of them because
Why are you needing several transcripts? I mean, let me just
I
ask
will
you.
explain. I will
Okay,
explain
time out,
in my
time out.
motion.
Stop. I get to
Yes, Your
talk.
Honor. Yes, Your Honor.
Judge, I'm sorry, someone's knocking on my door. I don't know if you can hear, but I can't hear you until I get rid of them.
Okay, let's hold off and let our court reporter go. Get rid of whoever is at her door, okay?
Okay, Judge, thank you.
All right, thank you, Ms. Gonzalez. All right, Mr. Lemnisos, before we had that, we took that short break, I was going to say to you, before you start ordering transcripts, I need you to really ask yourself the hard question, which is, are these transcripts something I need? In other words, did the trial court really get it wrong? And am I entitled to relief in the Court of Appeals? You're going to have to look at the law carefully on that. Because, like, as I said to you before, transcripts, if you're paying for them, they're very expensive, right? If the county
Yes.
is paying for them, they're very expensive. So I need you to make sure that I have to treat you as I would any other litigant. And you're going to need just a very clear head, good strong cup of coffee, good breath of fresh air, and really look at this and ask yourself, do I need to continue this fight or not? And I
Yes,
mean,
Your Honor.
you really got to make that decision, because the thing is, if you start going up on appeal with these cases, you may have to pay for them yourself. I don't know. I'm going to look at your affidavit of inability to pay. And then two, if the county is paying for them, it's going to be a time consideration for us. Absolutely. If you think you're entitled, we will help you with that appeal. But I need you to make a decision with your head and not with your heart. Not with your heart, but with your head, if that appeal is good. Okay? Can we have that agreement, sir?
Absolutely, Your Honor. I appreciate your direction, and I agree 100% with you. And if it wasn't, as you will see in a few moments when we start talking about the other motions, those are extremely necessary because it was a build-up. One error
Okay.
was
All right.
built on the other until we reached this point. So,
All right. Well, we'll get to that in just a minute. You asked me to do them one at a time, and we're doing them one at a time.
yes, Your Honor.
Let's go on to the next motion, which was your motion to set aside the default judgment. Tell me about that one.
Yes, Your Honor. The court held a hearing on the 5th and the 6th of March. This is a suit affecting parent-child relationship. The respondent, through her attorney, filed a frivolous suit for divorce. It is very clear to respondent and to her attorney that she doesn't have a good standing at all in the divorce, in the Sapser case, because she, violated our agreement and our agreement about the child conservatorship. The child, we had divorced almost 2 years prior to her filing her frivolous suit. The plan that the opposing counsel conducted from the beginning, and unfortunately for me, with the blessings of the court, in several occasions was to, since her client does not have any good standing in the Sapsar case, because the court has to consider all the factors that are to determine the best interest of the child. And so her plan was, let's get this whole thing confused and confuse the court with it. It doesn't matter what kind of process we use, what kind of ethics we step on. It doesn't matter. What matters is that we destroy this Sapsar case. The respondent pretty much her entire story, her entire narrative is false and fraudulent. With the fraud that she has committed by filing, if you will, I mean, even before the protective order that she got, she committed fraud, she committed perjury, she committed false statement to law officers, and subsequently, unfortunately, I had the luck to hire an attorney for that protective order that was completely, I mean, it's not incompetent from the evidence that is in the court. Once I get the transcript, that's why I need the transcript for the protective order, played directly to the prosecutor side, which in that case was the assistant county attorney on behalf of my ex-wife. Now, there are tons of issues besides the fact of her fraud and her false statement. She committed perjury right then and there in the courtroom on the witness stand, yet my lawyer failed to present the evidence, compelling evidence that I have provided. I have provided him the case, on a silver platter. He did not, he dismissed my witnesses, mind you, adverse witnesses. I called them, the state did not. I called the witnesses because I have the evidence that of their fraud statements and all. And I have evidence that CPS investigator not only didn't do her job, but went beyond her responsibilities and her lawful duties and assisted my ex-wife in kidnapping the child from the school. And all this started immediately after I served my ex-wife, who I brought back after. She is not a U.S. citizen. She is from Syria and hold both dual nationalities, Russian, because her mom is Russian, and Syrian. Now, we got divorced, we got married in Syria in 2016. In 21 days after our marriage, she called me. We spent one night together after we married, and I had to come back to the States because of my work. She called me 21 days and said, I'm pregnant. And I was contemplating at the time what kind of stupid mistake that I did with this marriage, because it was conducted within 10 days, literally, Your Honor.
Okay, let me stop you for just a minute, because I think we're starting to get off track, okay?
Okay, I'll get back to track.
Okay, it sounds to me like there were two issues that you want me to look at pertaining to your second motion, which is the motion to set aside the default judgment. And that is, they didn't really seem on point, quite honestly, pertaining to a default judgment, but I'll tell you what I thought they were. One was that your ex-wife perjured herself, and the other was that CPS had somehow or another assisted her in kidnapping or taking the child against your wishes. Is that correct?
Yes, Your Honor, but those are not the points that I'm basing these are just, I'm mentioning this to you because that's the buildup.
Okay, you better
And
get
that's
to
where
it.
the errors started.
Okay.
I mean, we got to the point.
Okay.
I'll skip some
Again,
of those.
now it's my turn to talk. I know it's really hard, but this is not a conversation, okay? My question is this. There has been a motion for default judgment against you, meaning you didn't file an answer or you didn't show up in court in some way. Why should I set that aside?
Your Honor, I did
This is
show up.
purely procedural. Why should I set that aside? Okay.
Your Honor, I been there. It wasn't that I wasn't in the court. I was in the court, but because of the errors of the previous orders, mainly rejection of denial of my motion for continuance several times,
Oh.
without even considering. I mean, if you have a quick look at the motion that I filed for continuance, I'm showing compelling reasons, mainly the reasons that the judge ordered the case to be removed from a jury docket, the conduct of the opposing counsel in manipulating and misusing, I don't know what's the legal term, but she manipulated the discovery process while she knows I was objecting to the divorce to
Wait,
begin with.
I'm sorry. Who manipulated the discovery process? Your
Miss
ex-wife?
Lundwitz.
Miss
My
Lundwitz.
ex-wife, through, of course, she doesn't have the capacity to
Okay.
conduct such a strategy.
So
But
here's
Miss
again,
Lundwitz
stop. Here's what I understood happened. That you announced that you were not ready at the last hearing based on the trial being unfair. Is that correct?
based on the trial being more than unfair, it is not proper, Your Honor. This is a case of a Sapser case, and it was turned into a divorce case fraudulently, and unfortunately, to my misfortune, by errors in judgment, by two judges.
Okay.
No,
All right. So
three actually.
all right. All right. Let's go on to the next one. So that was your second one, was your motion to set aside default judgment. And let me tell you what I heard you say is that the reason why you announced not ready for trial because you thought it was unfair was because Ms. Lungwitz, who's the attorney for your wife, your allegation is that she manipulated the discovery process and thereby made the case unfair to you. Is that correct?
Not only that, she did not only manipulate the discovery, she manipulated the I don't know what's the term to use, but the mutilation of my case. This is not a divorce case. She, number one, provided misleading information and flat out, apologize to say, flat out lies to the court. She misled the court the first time. Her misconduct was that she interrupted the hearing on my first time. I filed a motion to dismiss with prejudice and motion for sanction the first time. The court started hearing the motion, and I called my first witness, who was my ex-wife, and Ms. Lungwitz interrupted right then and there and told the judge the misleading information that I cited a law that it is not does not apply to family law, namely 91, the one about judgment without basis of law.
So here,
I explained.
Stop again. Stop, Mr. Lemnisos. Here's the situation. We're happy to have you here today. You're an honored member of our court. Making allegations that Ms. Lungwitz lied, that's not going to. here's the situation. She's an officer of the court, and
Yes, ma'am.
I don't see indication here at all that she lied. So
There is a point, Your
no,
Honor.
but okay. Let's just back away from that a little bit. Let's just
Yes.
say this, you didn't agree with what she said, okay? I mean, I think lie is a pretty strong word to use in this tribunal, in my view. It's strong, right?
I would draw that, Your Honor, about what I insist on, that she provided the court with misleading information.
All right, well,
And
that's to be
that's
seen.
evident that's very evident in both her answer to my motion that she filed, and flat out, she claimed to the court that I am basing my motion on Rule 91. And I tried to explain to the court, I said, where is it? Show me. Where is in my motion I have put Rule 91? There is no Rule 91. I'm basing my motion on res judicata, because we already had divorce, on collateral estoppel also, because the issue of divorce has been litigated already. There was a final judgment, and I'm basing my motion on the principle of committee. All these were the basis of my motion to dismiss.
All right.
And then my motion for sanction was based on Chapter 10, and she claimed, Ms. Lungwitz claimed to the court that and the court, unfortunately for me, agreed with her, interrupted the hearing after I started making my argument, and denied the motion, stopped the hearing, denied the motion, and then did not issue an order so I can, I can challenge it till after like 7 or 8 days.
Okay.
Now, the very next day, the court heard another motion of mine. It was to vacate the court order, or Judge Dilayata specifically made an order also accommodating Ms. Lungwitz's summer vacation, and gave her a continuance. I originally set the date for my SAPSA case for the end of.
I'm sorry, can you repeat that? Granted the continuance and then?
Granted the continuance for unlimited. It wasn't a continuance like, okay, in this date and time. Ms. Lungwitz filed a motion to appoint guardian ad litem, also with misleading information to the court, because she didn't actually want a guardian ad litem. She wanted the biased, corrupt guardian ad litem that was assigned by the court on a very, very limited scope by the court of the Judge Hascock of the protective order.
Stop. You need to hit a big hard stop on this. Judge Hascock appointed a guardian ad litem in this case, Ms. Lungwitz. Who is No, do not speak. Who is the guardian ad litem, Ms. Lungwitz?
Well, the one he is referring to is Stephanie Lovelace. That was the protective order guardian. We filed a motion to appoint a guardian. She was appointed by the judge sua sponte in the protective order case.
Okay.
Then when this case began, we requested that the court appoint a guardian, and we suggested that since Ms. Lovelace was already familiar with the case and had already investigated and prepared a report, that she be appointed to continue the appointment. Mr. Lemnisos opposed that, and so the court appointed a new guardian, which is Marilyn Martinez, out of the Domestic Relations Office, and she was appointed guardian in this case, and she did her due diligence and wrote a report.
Okay. That's what I need to know. Thank you, Ms. Lungwitz. Okay, Mr. Lemnisos, we need to move on to your next motion, because I get it, that you feel like the motion You have a motion
Your
set
Honor,
aside. No, no, not yet. You've got to learn when it's not your turn, and that's not your turn. There's several issues here. One is that you say your wife perjured herself. Number two, you're saying that Ms. Lungvitz, I think, misrepresented some things to the court. I'm not sure that I agree with that, but we will look at it. And then thirdly, that you feel the guardian ad litem, Marilyn Martinez, who replaced Stephanie Lovelace, that she was corrupt. Now, anything else on that motion? Are you timed? I mean, you asked for this accommodation. I'm giving it to you. You want to go each at a time, but do we have anything else on the default before it's time to pick up your motion for a new trial?
Your Honor, I need to clear all the points that you just mentioned. These are not my only points.
Okay, what
My
are your
biggest
how
problem,
many more? What's your biggest problem? Let's
a
get to
lot,
it.
a lot.
Well, I got it, but it sounds
That's why I requested,
it sounds to me like what you're arguing now is the motion for new trial. Yes, because you announced not ready for trial in the motion for default judgment. You've told me the reasons why you weren't ready, but it sounds to me like we're moving into the motion for new trial, and I want to get to that for you. I want you to have time to argue that. Where are we with the motion for new trial?
I'm sorry?
Where are you on the motion for new trial? What's your argument? Why do you need a new trial?
Can I finish the point for the motion to set aside the default judgment? I'll make that very short and quick.
If you'll make it short and concise.
I will.
But
I will.
we're kind of starting to wobble here, they say, Mr.
I understand.
Lewis. We're wobbling
I
on the
understand.
topic, and we need to. I wish we had all day, but it's a little bit like everything else. Judicial resources here are somewhat limited. And so when you start to go way off point, you can imagine if every single person did that, we wouldn't have time to hear all the cases. So please, let's get back on point and wrap up your second motion, which is the motion to set aside default judgment, okay?
Okay.
Please wrap it up. Big points. Let's go.
The first point is my absence was not as defined, like for indifference or I knew, but I had strong reasons for not walking into what I considered pretty much a trap that was set based on several, not one or two or three or four, but several errors and orders. One was built over the other based on the false misstatement made by Ms. Lungwitz. Now, that's my first point, is my absence was not by choice. The court decided to take this off of the jury docket. First of all, Ms. Lungwitz violated an court order. The court specifically ordered that the final setting will be either by agreement or by the court. And Ms. Lungwitz went ahead and set the date when it was suitable for her. I objected the first time, the second time, the third time. When the Honorable Meacham heard my motion to strike her settings, Ms. Lungwitz's setting, on the 5th of March, Judge Meacham removed the settings, like struck the settings, yet reset it for the same date and time, like March 5th, except that she set it on the jury docket if I wanted to file for jury, which I did. Now, the court removed the judge, removed the jury, removed the case from jury, put it on the, those are the reasons why I couldn't walk into the trap. Because it was obvious what's the whole thing is gonna be. This is not a divorce case, and they want it to be a divorce case. Now, I am going, the objection to this entire session was because I want to challenge significant errors and abuse of discretion by the court that proceeded with the hearing despite my very valid and strong points twice the court stated, Judge Meacham stated that she heard my motion for continuance on the jury docket call, and she didn't. Ms. Lungwit's motion to enforce the scheduling standing order was not scheduled that date, yet Judge Meacham supposedly heard it, did not hear from me, my response to it, just immediately because she was in a rush, as the transcript will show, and ordered denying my motion for continuance without prejudice, yet stated that the judge who is assigned to the case will hear it, like at the moment of the trial. I don't have any recourse if I can't challenge that denial of motion for continuance, and the court will go on without witnesses, without evidence, without anything from my part at all. She combined a divorce and protective order, and the SAPSA case was dead. So that's my second point. My cause of action also is I have a very, very strong defense and valid meritorious defense against this frivolous divorce suit, against the protective order, against each and every item that was mentioned in that so-called divorce case. I requested, following post the trial, I requested finding of facts and conclusion of law. I first requested that after the first denial of my motion to dismiss, and Ms. Lundquist herself, that's what I say, provided misleading information, suggested when the court asked her to provide as a prevailing party proposed finding of fact and conclusion of law, even though the honorable judge stated that it was a matter of law. It did not discuss the merits of my motion. So Ms. Lundquist suggested that this is not a final order, and with such, there is no need for finding of fact and conclusion of law. And then there is a necessity for the new trial. The order resulted from final hearing is not going to affect the respondent one way or another. If they are reversed, if this entire lawsuit and the divorce and protective order all reversed, I should mention, if you allow me, just your honor, that there are two criminal cases.
Are we on, stop. Are we on motion for new trial now, or are we still on?
Yes.
Okay, good. Yeah, we've
still,
changed the last one. Way to go.
We still, I mean, they are sort of intertwined together.
What else do you want to say about it then?
About I
motion for new trial. You're on that one now. Tell me about it.
Okay. May I have 1 minute?
Yes.
This motion is basically based on the entire process in this SAPSA case from beginning to the end. And that's where the erroneous orders that were issued by the court granting blessings to the opposing counsel plan to destroy the SAPSA case and get this. I'll leave it to the court to name what kind of a decree that was issued. First of all, the court started the case with, if you look at the docket, it says divorce. This is not a divorce case. The divorce case is fraudulent, and I filed twice to dismiss it, and twice the court did not rule. The first time, Judge Grump denied my motion as a matter of law, stating in her order, if Your Honor would have a look at it or want me to show it on the screen, she stated literally that because I cited the wrong law, simply, where I didn't. And she named it. She named Rule 91 or Federal Rule 20 or 21, I'm not quite sure. But bottom line, the first time the judge did not rule on that. Bless you.
Thank you.
The second time, Your Honor, Judge Meacham heard the case. First of all, Judge De La Yata, out of his own choice, it wasn't, I did not request anything to do with the divorce case. My motion was simply to order Miss Longwitz, admonish her from using the divorce caption in the marriage of, which she was wrongfully using. She changed the caption of the case from a SAPSER caption, Marius versus Dima in the interest of the child, into in the marriage of. She started that way early when she filed her motion for continuance, and that's where I'm saying she misled the court. In her proposed, Judge De La Yata has no clue about divorce or what have you.
Wow. Now, see, here's again, Mr. Lemney says, stop. Okay. When you start, we have officers of the court, we have judges and attorneys. When you start throwing out words like that, like Judge De La Yata has no idea about divorce,
I apologize. Can I rephrase, please?
No, you need to back off on that type of thing. It's like saying Ms. Longwitz is a liar. Like, that is not helping you at all. It would be a little like me going over and criticizing, I don't know, a NASA rocket or something. You need to keep in mind that folks here do have a reputation. And Judge De La Yata, to say he doesn't know anything about divorce, you don't know what you're talking about.
That's not what I meant, Your Honor.
Yeah, you need to back off on that. And you need to wrap it up.
Can I explain, Your Honor?
No.
Can I rephrase?
No, don't explain why you just cast aspersions at Judge De La Yata. You just sit with that.
I did not. What I meant, I misspoke, Your Honor.
Move on. Keep talking. Why? I'm looking at Crump's order here, and it's not making any sense to me, because what you're saying is not making sense. It says the court finds on February 5th, after the court denied petitioner's motion for continuance, petitioner, that's you, refused to participate in the final trial and voluntarily left, period. The court further finds the final trial took place on February 5th and 6th without you present. What am I supposed to do with that? You walked out the door. So I'm not understanding where we're coming from with this, Mr. Lemnisos. What's your issue?
I need
you walked
to explain.
Out. You lost your place at the table. Why would you do that? That's not smart. Where are we with this?
Your Honor, if you're not going to let me explain, I can't present my case to you. You're not letting me explain.
I have let you. We've been sitting here for 45 minutes now, and I've let you explain.
That's why I requested you.
We have not got any
problem.
Okay, stop.
I already did.
Stop. You may explain, but I do not want you casting aspersions on any other court personnel. You may continue your explanation, but we need to get. But again, you're starting to wobble. You need to stay on point. You started this by saying you wanted an accommodation. I granted for you immediately. But we need to get back to that point, and you need to explain to me why a new trial is warranted when you walked out in the last trial. All right? So let's get rolling on that. Go ahead.
I request Your Honor permission to just explain myself. I did not mean any. When I said that Judge De La Yata did not have a clue, I meant he did not have a knowledge about any divorce. He knows that this is a SAPSER case. in her proposed order for continuance, she presented to Judge Dilayata with the false caption of divorce. That's what I wanted to say.
All right,
I
very
have
good.
absolutely nothing to say, even about Judge Crumb or any judge. I have utmost respect to their person and their position. Now, the started this by using that caption fraudulently. This is against the rules. She cannot change the caption without approval of the court.
Who
Now,
is she here?
Miss
Your wife?
Longwitz, I'm
Who's
sorry. No,
Ms.
Miss
Lungwitz?
Longwitz.
Gotcha. We're
Miss
back to Ms.
Longwitz.
Lungwitz. Okay.
Yes, ma'am. Now, I mean, it's all my ex-wife, but the actual, person who is doing this is Miss Longwitz. My wife has no idea about the process of the law. Other than providing fraudulent information to Ms. Longwitz, her role ended there. Judge Dilayata, then, the very next day of the first time that the court heard my motion to dismiss, Judge Dilayata, he wasn't, I didn't ask. He asked me, what relief are you seeking? I said, I'm seeking two points only of relief. Point number one, to vacate your order of open-end continuance, because it's really very imposes very hardship on me. It has been already over 90 days, and Ms. Longwitz's reason for asking for the continuance was to have time for the ad litem to conduct her business, even though I have to mention for the record that the guardian ad litem, Ms. Longwitz, omitted from her statement about both guardian ad litem that they were both assigned on a very limited scope. The first guardian ad litem was assigned merely, it started her assignment after the court, and it wasn't like in the middle of the process. The judge wanted me to see my child. I have been deprived of my child for a very long time when the final hearing on the protective order happened. So he ordered that the DRO office, immediately, it was his literal word. And so that was, and then she did not do her job. She even filed her report 9 days after she was dismissed by Judge I'm sorry, apologize. Court, that heard the case. Judge Lytle, I believe. I don't want to misspell.
Yeah, Justice
Yeah, I don't want to misspell her name, but the honorable judge heard my oral motion about the previous guardian ad litem and heard my argument about why Ms. Longwitz wants that particular person to be a guardian ad litem, and the honorable judge decided to dismiss the guardian ad litem and then ordered a new appointment for guardian ad litem. However, not corresponding to what Ms. Longwitz requested, which is deciding on conservatorship, she also gave her the exact same limited scope. Provide the court, first of all, conduct an investigation whether a family violence actually occurred or not. And the second was to provide the court with proposed exchange, visits, scheduled, what have you. That was the reason. Now, when Ms. Longwitz applied for continuance and stated that she wanted the guardian ad litem to have her time to do her business, and she herself, Ms. Longwitz, need time for discovery. At the time I filed this motion with Judge Dilayata, she has not done a single thing about discovery in the Sapsar case because she wanted to wait until she pushed this divorce thing on. Now, we got to the point where Judge De Leada, following the first time, on his own, told Ms. Longwitz, you cannot file a countersuit for divorce if there's no divorce. And that was when Judge De Leada gave direction to Ms. Longwitz to replead her divorce if she wants to divorce, to file for divorce, in a motion for divorce. However, the Honorable Judge made a little mistake here, error in judgment, which is allowed her to file the divorce case into the SAPSER case. This is exactly against the rules. The rules are not you file the divorce into the SAPSER. You file an independent motion for divorce, a filing case, and then the law states and the rules that if there is already a SAPSER case when the divorce is filed, then the SAPSER case should be joined to the divorce, not the other way around. You do not join the divorce into the SAPSER case and take that case number. Those are the rules, Your Honor. I have the if you'd like me to, but it is mentioned in my motion. Now, next day, Ms. Longwitz filed, or a few days later, she filed for divorce, but she filed it in the SAPSER case. The Honorable Judge gave her two options. He said, because what he was hearing is my request to stop her, admonish her from using the wrong caption. And the problem was, he said, she has the option to file into the SAPSER case, and he cited the law that they should be joined, but the error was this is not the way they are joined, and they are not joined arbitrarily. Like, she cannot just join them. She has to file a motion. She has to file a separate motion for divorce, and then file a motion to join, and then the court will order the joinder of SAPSER and divorce. Now, she didn't do that intentionally because she knows where she stands when she files a separate motion for divorce. Immediately, I will move into dismissal, or in other scenarios, maybe for summary judgment or what have you, because we already divorced 2 years. 2 years we're divorced before she filed for her divorce. And my ex was living overseas for almost the entire school year, first school year of the child. We had an agreement post the divorce that the child will come back to state with me and will stay with me. My child is autistic, Your Honor, and needs a lot of care and follow-up and therapy. So that was our agreement. And following that, I brought her back after, when the child was about to finish school. I brought her back, and then, she did what she did. After I served her with the eviction notice, she went and concocted this whole thing. Now, the other point is, when I filed the second time for the divorce, before that, Judge Crump heard, like you said earlier, Your Honor, Judge Crump's supposed to hear this. And the same situation was with Judge Hascock. Miss Boyce, without authority, she was not the court. She wasn't the attorney for my ex in the protective order case. That was a separate case, Your Honor. The protective order case, Miss Boyce, that's where the complications start to pile up, Your Honor. So please be patient with me a little bit. I have to explain this to you. The Honorable Judge Hathcock issued the protective order, notwithstanding, I mean, let alone the fact that it was extremely harsh. But at the same time, when it comes to the child, he was practically waxing lyricals about my care for my child, and that's why he ordered an immediate visit. However, honorable judge did not make an order on visitation, exchange, custody, conservatorship, or anything that has to do with the child, nor did he make an order on child support. The judge stated in his final in his order recital, if you will, or final statement, that these two issues, important issues for the child, will be heard, will be determined later, on a later date. Now, that later date never came. I did not know what to do. I immediately, after the protective order, filed for a de novo hearing, couldn't, but I'm not going to go into details about this. But the bottom line is the judge did not issue an order. Now, Miss Boyce sent the court a letter. She did not file a motion or anything. Sent the court administrative assistant a letter using the transcript that I paid for the final statement of the judge's ruling. Basically, she used that to ask the assistant in the court, the administrative assistant, say, we looked into that and we didn't find any child support order. Can we have a child support order? I mean, I don't know under what law that happened. The court did not have jurisdiction, lost its plenary power at the time. It was almost a year between the time that the honorable judge issued the final order and between the time that she asked for the child support. So the honorable judge granted, first of all, responded. The honorable judge responded that the child support should be based on the minimum, on the presumption of a minimum wage. Now, I understood this as the honorable judge was giving Miss Boyce an advice or an opinion as to, in the Sapser case, since the judge in his final ruling said that I'm not going to rule on child support now, maybe a Sapser case will be filed down the stream. Somebody will file a Sapser case and those will change the dynamics. Okay, so the court did not have jurisdiction, did not have plenary power, yet after Judge Hathcock provided the response to Miss Boyce, before even an order comes from the court, she started sending me a proposed order to pay child support in reverse, like with a arrearage from January. Now, I did not, of course, sign. Instead, I sent the court a correspondence, a letter or an email, if you will, and I asked for clarification from Judge Hathcock. Is this an advice or is this an order? This is an order on child support. It requires a hearing. It requires a motion. It requires Miss Boyce or Miss Langwitz to show authority. They are not her attorney. So I mean my ex-wife's attorneys in that particular case. Eventually, Ms. Langwitz filed an appearance as my ex-attorney and acquired an actual, provided the proposed order to Judge Hathcock. Judge Hathcock also, without a hearing, signed the order and issued it. Now, that was one of the first, of course, Ms. Langwitz did a couple of things before that, but we're not going to get into that because they're related to the protective order issue. Now, and that's going to have its own process. Now, after this, I filed a motion to set aside this child support order, to vacate the child support order. This, as Your Honor just explained, according to the local rules, supposed to be heard by Judge Haskell. Instead, in a miraculous way, was heard by Judge Crump. Judge Crump did not hear or rule on my motion for to dismiss the child support, did not let me argue why it should be dismissed. Instead, Ms. Longwitz, again, that's another aspect or strategy of hers, is to confuse the court, start getting all issues together and start talking about the protective order and what happened in the protective order, and then the honorable judge, out of the blue, without even an evidence, I should say, request from the opposing counsel, issued a sua sponte order to consolidate the protective order with the SAPSA case. Now, the law says nothing about consolidation. These two are totally different issues. The law states that the protective order should be transferred, not consolidated. This protective order was issued under a different family chapter than the protective order usually issued under the SAPSA case. And that's where the manipulation of the rules and the law and the misleading stays. Now, Judge Crump issued that order. With that order, Ms. Longwitz prevented me, as she was trying for a long time, from challenging the protective order, and mixed up the SAPSA case more and more. Now, great. The honorable judge, again, did not provide me, even though I objected and I immediately explained that, this is not what the law says. The law says that there is no consolidation. There is those two are totally different things. You do not consolidate a protective order with the SAPSA. You issue a protective order within the SAPSA under a separate chapter of the family codes. It's not, and in evidence that it was intentional, the Honorable Judge Crump, in her final decree, specifically mentioned that no ruling of this final decree will affect the protective order. So, it was known to the Honorable Judge that this is not to be touched. Yet, if you have a quick look at this horrible, I should say, final decree of divorce, it's practically an order, terminating my parent-child relationship without naming it as such. No visitation, no contact with my own child, even though there was absolutely no claim, not only evidence, no claim of any violence directed or neglect directed towards the child. CPS investigator reached that conclusion few days after she started her investigation, yet in order to facilitate and help, unlawfully, I should say, help my ex-wife kidnap the child from school, did not provide me with that report that they cleared me out of.
Okay,
child.
Here's our situation. You've been talking for over an hour, which is pretty extraordinary, quite honestly. I don't typically allow that. So we're going to ask you to stop now. We're going to take a break, and all of us we're going to let my court reporter rest her hands. We're all going to use the restroom, and then it's Ms. Boyce's opportunity to talk. So you need to go on and wrap up. Any other things you want to say to me before we take a break?
Yes, I mean, am I gonna be able to at least sum it up real quick?
No, at this
Because
point,
if
you've
you
already
don't,
summed it up. You're kind of done. Okay, we're going to take a break now, and then we'll come back and we'll hear from Miss Boyce. All right, everyone, keep in mind, I can of course hear you if you keep talking, so you might want to keep in mind I'll hear your comments. We're going to take a 10-minute break. We'll come back on in 10 minutes from now. All right, court's in recess for 10 minutes.
Thank you.
A few minutes later, a little longer than a few minutes later.
All right, folks, let me turn back on. Let me close this door.
Your Honor, if I may.
It's not your turn anymore. Now it's Miss Boyce's turn. Miss Boyce, how do you respond?
Today, we ask the court to deny Mr. Lomnisos's motion to set aside a default judgment and his motion for a new trial. With respect to the motion to set aside default judgment, we note for the court that the final order was not a default judgment as defined by Texas Rules of Civil Procedure.
Not too fast, not too fast. You're doing good, but keep in mind, always when you're in court, there's a court reporter taking down everything you say. So while you're reading it and you can go kind of fast, my court reporter cannot type that fast. So slow down and keep going, okay?
My apologies. The final order was not a default judgment as defined in Texas Rules of Civil Procedure, Rule 503.1. The final trial was set for February 5th, 2024, and Mr. Lomnisos appeared for trial. He urged a motion for continuance, and Judge Crump denied that continuance. Mr. Lomnisos then chose not to participate in the rest of the trial and left. He had the opportunity to participate and chose to leave. The order signed by Judge Crump reflects this sequence of events in the appearances section on page 1 of the final decree, filed on February 21st. Accordingly, this final order is not a default judgment under Rule 503.1, and the motion should be denied.
Okay.
With respect to Mr. Lomnisos's motion for a new trial, it should be denied as the evidence at trial supports the court's final order. There has been no error regarding the setting of the final trial or the actual notice given to petitioner regarding this trial. The record reflects evidence that is factually and legally sufficient to support the court's final order. Additionally, the record reflects no abuse of discretion by the trial court. There is no good cause to set aside this judgment as required in Texas Rules of Civil Procedure, Rule 320, and nothing in this case meets the threshold for reversible error set out in Texas Rules of Appellate Procedure, Rule 44.1. In conclusion, Your Honor, both the motion to set aside default judgment and the motion for new trial should be denied. Mr. Lomnisos has received far more process than he is due, with litigation stretching for more than a year, and with more than 10 hearings and a final trial since litigation began. Today, we ask the court to deny both of these motions.
Right, thank you. Anything else?
If there's anything that Mr. Lomnisos brought up that you would like us to address, we're happy to do so, but that's the gist of our argument today.
All right, thank you very much. Mr. Lomnisos, let me ask you a couple of quick questions about your income.
Yeah.
Are you currently employed, sir?
No, Your Honor. I haven't been employed since June 2020. In the pandemic, I was overseas before my ex-wife got her green card, and I brought her to the United States for the first time. After filing her, starting this whole process by filing the protective order, there are 2 criminal cases that are going to be heard for the first time since then. On the 20, I apologize.
Okay,
on the
let me have
20
another question for you. Stop. Are you?
Your Honor is not letting me
you gotta stop. You
answer
gotta
your
let me
question.
talk. Mr. Lemnisos, we have extraordinarily given you a full hour to do nothing but just talk without many interruptions other than me asking you not to call people liars and me asking you not to cast aspersions on a judge's knowledge. That's it. Now I have another question for you. Are you currently receiving government assistance?
Your Honor, if you're asking me questions and I would not get
Answer
the
my
opportunity
question.
to
Okay,
answer,
okay.
I have a right to make
No.
my case, Your Honor.
Stop.
I have a right to answer your question.
Stop. Are you currently receiving government assistance?
I'm receiving Medicaid, and pretty soon, unfortunately, I'm gonna start receiving assistance for housing and bills and even food.
All right. Okay, now I have another question for Ms. Boyce. Let me go back to you, Ms. Boyce. So I'm looking here, and the rule that I think you cited to is Rule 503, but I think that pertains to the justice courts. Am I right? Isn't it 239A that pertains to district courts? Or where are we with that, Ms. Boyce?
My apologies, Your Honor. I may have miscited a rule. We can find it momentarily.
All right, why don't you take a minute and do that? All right. So we're about to wrap up for the day. What else do you think I need to know, Mr. Lemnisos, while she's looking at the rule before we wrap up?
I request that the Honorable Judge give me even 5 minutes.
You've got
to
5 minutes.
Okay. First of all, regarding her objection, I just want to add, it's going to come in my summary. I summarized my motion for a new trial based on the errors that was done, an abuse of discretion by this court, by removing the case from the jury docket and placing it on the bench trial based on the respondent false statement that I did not comply with the request. I did answer. Number two, the court abused its discretion by not granting and squeezing me in a point where I was heard for the motion of continuance the very moment, just a few minutes before the trial. And one of those major points was I am entering a trial, A, on a different case, B, without any witnesses, without any evidence allowed by me. Three, and that constitute abuse of discovery by the opposing counsel. Now, I announced, I requested permission from the court, and I specifically stated to the Honorable Judge that with all due respect, I mean, I don't want to offend the judge or cause any, but I cannot participate. And the Honorable Judge said, you don't have to participate. And that's when I asked to be excused and I left.
Is this Judge Crump where you walked out? Is that
yes,
correct? Okay.
Yes, Your Honor.
Okay.
Yes, Your Honor.
She said you were there and you left. You walked out of the courtroom. Is that right?
That's not accurate, Your Honor.
Okay. Well, what is her court? What does she mean then? He left. How did you do that? How'd you get?
Yeah, Your Honor, this entire decree that you're looking at right now.
All right, just answer my question. Did you leave the courtroom or not? Yes?
I did leave the court after I explained to the judge the finding of fact and conclusion of law, as well as the final decree of divorce, were prepared by Ms. Lungwitz, not by the judge. The judge simply signed both of them. Now, my other points, just to try to catch my time, I announced not ready before it started. I declared at the beginning of the session that I'm here only for the continuance motion. I am not ready in any shape or form for the final hearing on my Sapser case. The court abused its discretion when it set the final hearing date in response to the same date that the opposing counsel set twice. The first time when the court set it on the same date for a jury trial, and the second time when the court withdrew it from jury trial, assigned it to a bench trial at the same date as well, based on the claim by a respondent that I did not answer the discovery. And you can see from the evidence that I did answer, she just didn't like the answer. Now, removing, the court removed from jury docket, and then the honorable judge issued a judgment. Absolutely, Ms. Boyce just stated that the evidence, why that evidence wasn't presented in the conclusion of finding of fact and conclusion of law. Not a single piece of evidence support any, and I do mean literally any, from the statement that the court find that these two are married. Where is the mention of the divorce? It wasn't challenged to say that the court find that no, the divorce is not valid, or it was not challenged, it was not mentioned, it was omitted. Hence, the proper filing of this, the papers, the statement of the court, or I should say adopted by the court, is not accurate. The filing is not proper and did not meet the requirement. All that, each and every out of 60, the final decree is 30 something pages. The finding of facts, supposedly these are finding of facts. I request that Your Honor just have a quick look at them and see where are the finding of facts. It was literally just repetition of whatever came in the final decree. It says that the court finds that they are married. Okay, where's the evidence? On what evidence did you base your findings? That's the other thing. Conclusions of law, none. There is only one single mention of a law in the conclusion of law. Out of 11, only one. The other all repeat again for the facts. There is no conclusion of law. It doesn't say that, okay, we applied this law into this finding, and that's how we ordered this order. So there was absolutely, I filed after receiving this supposedly finding of facts and conclusion of law, I filed specifically a request for additional and amended filing of fact and conclusion of law. Again, the court asked Ms. Longwitz to provide a proposed by a specific date, and Ms. Longwitz provided an answer saying that respondent, not the court, respondent doesn't see any reason for additional finding of fact and conclusion of law.
I've now let you go for 6 minutes and 34 seconds. You need to wrap it up, please. Okay.
Thank you. The only other two things that, besides that, there is absolutely no evidence. In addition to all that, the court abused its discretion when it transferred the Sapser case into a divorce case unlawfully, based on the false statement provided by the respondent. And the court abused its discretion when issuing orders, entire orders related to the child, which is the core of the Sapser case, based merely, even if notwithstanding whether the protective order is valid or not, even if it was valid, the other factors that the court should consider in determining the best interest of the child was shot. There is not a single mention of that. And as far as finally the property division, also there is no evidence. What property they were asking, and the court ordered that I provide her with my car that I sold over 2 months prior to that. There was no evidence of any property, and most importantly, the court—
Okay, you've got 2 minutes to wrap up, sir. 2 minutes.
Thank
I'm
you.
stopping you, hard stopping you. at 2 minutes. I said 5. You've taken almost 10. I've been patient with you. But in 2 minutes, there's a hard stop coming. So please, please tell me the last things and let's stop, okay?
Okay. The last thing is the property division, supposedly, and the child support. All these orders required to have the other statement, that not accurate statement in the order or the decree, if you will, even though it mentioned that there is a required hearing and judgment, there was no hearing done. There was no, hence the default factor of this. This entire session was done without any counter evidence, without any actual evidence that presented. And once I received the transcript, I will prove, in addition to proving all the rest of the fraud that the respondent committed in the upcoming criminal case. She will be exposed in the criminal case, and that will be another story. Now, all these
You've got 30 seconds.
conditions, all these previous conditions rendered entirely improper judgment in this case, according to the Court of Appeal rules, the rules of the appellate
All right,
court.
so we're now
44.
rolling up on 10 minutes. Hard stop. Okay, very good. Ms. Boyce, let me hear from you now. You had asked you about a rule. Tell me what you found out about that.
You were correct, Your Honor. We asked that the court deny this judgment based on, or deny the motion to set aside default judgment based on Rule 239. My apologies.
All right, very good. Okay, so in terms of the motions, the motion to approve the inability to pay is granted. The motion to set aside the default judgment is denied, and the motion for new trial is denied. Ms. Boyce, I'm going to ask you if you would please craft an order. Do give Mr. Lemnisos 24 hours to review it. If he does not get back with you within those 24 hours, then just send it directly to the court. After that, I want you to send it at 455.submission@traviscountytx.gov. Again, 455.submission, singular, @traviscountytx.gov. And make sure in the subject line write HO, which means hearing order. Okay. Now,
Yes.
if he gets you some comment about it within the 24 hours, just forward that comment to me. The only thing I want him to do is approve as to form. He's never going to approve as the content, I understand. But I'd at least like to give him an opportunity to approve as to form. And the way you do that is you put a little signature bottom at the form. It says approved as to form only. My expectation, since this will be a quite simple order, is that Mr. Lemnisos will sign that approved as to form only. But if he does not, give him 24 hours to review it and then get it to me. Now, it's Monday right now. I would like all this to be completed by 5 o'clock on Wednesday. So draft the order, get it to him, give him 24 hours, get it back to me. That should be more than enough time by 5 o'clock on Wednesday. Then we'll sign it and we'll get it back to you. If for some reason I don't hear from you, it gets to be a problem for me because we have so many cases. So please, please don't lose track of that deadline. Okay. All right. Very good. Thank you all for being here today, Mr. Lemnisos.
Just a question.
Yes,
a question
sir.
about your ruling. You did not rule on the fee waiver.
I did. I said I granted your fee waiver.
Okay.
I
I'm sorry, I
did.
didn't hear that. I heard only you granted.
No,
the-
well,
okay.
I granted the fee waiver and denied the other two motions, the motion to set aside the default judgment and the motion for a new trial.
And
all right.
Can I ask for orally for a finding of facts and conclusion of law, or it doesn't apply?
I think you have to wait till the judgment is signed before you can request a findings of fact and conclusion.
Yes.
Well, so it hasn't been signed yet, so right now you can't. Okay, very good. Ms. Lungvitz, anything else, ma'am?
I just have a couple things. First, we do have we have uploaded orders on the motion to set aside and the motion for new trial, but
Okay.
all we'll need to do is add the approval lines, so Mr. Lemnisos can see those there, but we'll also send him send that to him today.
Oh, very good.
Um,
He has 24 hours to review it, just so that he has time. And again, it says to form. I would not expect him to ever approve us to the content, but we at least, I think, need to give him the opportunity to approve us to form and then get it back to the court. All right, Ms. Lindwitz, what else?
The second thing is there is a qualified domestic relations order that we have drafted for the purpose of dividing up what a Fidelity investment account. We had planned on sending that to Judge Crump since she signed that order, but once we got assigned to you, we decided to wait. Would you like for us to send it to you or submit it to Judge Crump?
It's fine if you want to send it here. We get our things signed very quickly. So just send that on over the Quadro. Ms. Lungwitz, was the Quadro drafted by an attorney who works in that area?
It was, we got from Fidelity Investments their suggested order, and it's drafted based on that. So no, it was drafted by Ms. Boyce and reviewed by me.
By you.
Just for judicial.
Mr. Lemnisos, you've been talking so much. Others have to have an opportunity, and I'll give you one more chance, but let me just finish hearing from Ms. Lungwitz, because we've heard a lot from you. Ms. Lungwitz, anything else?
And the very last thing, this is just to put on the record, Mr. Lemnisos has sent a process server to my office now twice, attempting to serve me with a subpoena for Ms. Alzaknon. And I have let him know that I am not accepting service. It's in a different case. It's not in this matter. And I just wanted on the record that I am not accepting subpoenas on behalf of my client in other matters.
All right. So Mr. Lemnisos, the attorney has told you that she's not accepting subpoenas on behalf of her client in other matters. So you please need to stop sending those to her, the process server to her office in that regard. Okay.
I'm not sending anybody, Your Honor. Those subpoenas were issued, and Miss Lungwitz accepted them, number one. Number two, because of the protective order, I am ordered that not to communicate with the respondent in any other way. And the only, when the constable asked me for address for Miss Alzaknan, I explained that the only person who knows her address can provide it to you is Miss Lungwitz, and previously Miss Lungwitz accepted and now accepted the subpoena.
Okay, but it's in a different case. That's the situation here.
I understand, Your Honor,
so you need
but
to
I
stop.
have no.
You need to stop sending those to her. She's not accepting. She is not accepting. Stop. You do not stop. If I had a gavel here, I would bang it. Okay, let me just say that. She is not accepting. No, she is not accepting. She is not accepting service or process in another case. Please stop having the process server go to her house. All right, anything else? Stop. Okay, yeah, thank you, Ms. Guardiola. Anything else, Ms. Lungwitz?
No, Your Honor.
Okay, very good. So let's go in and get these, orders to him. I realize that he's very, very doubtful that he will sign off. I think the only reason, Ms. Boyce, is I just feel like we at least need to give him a chance to review that.
Yes, Your Honor.
So get that to him, and if he doesn't, we'll just write in there that you gave him as much time as 24 hours, and that certainly is enough time for him to review orders. We'll get that signed, but don't lose track that I need it back by 5 o'clock on Wednesday. Okay?
Yes, Your Honor. Thank you.
Thank you, Ms. Lungwitz, Ms. Boyce, Mr. Lemnisos. Thank you all, and I wish you all a very pleasant rest of the day.
Thank you.
You may be excused.